Madam Chair and members, thank you. This Senate Bill 1399 is the result of my annual There Ought to Be a Law contest, which some of you are familiar with, and it deals with the Solar Shade Control Act, existing law, which, under threat of criminal prosecution, bans a tree or a shrub from shading a neighboring solar collector with certain exceptions. The bill is not, in my view, designed to pit solar versus trees. Let me make a bold statement here. I'm pro-trees and I'm pro-solar, okay? I'm okay with both of those things, and I suspect that's where most of the committee may be. That being said, the question that always faces us is how can we balance legitimate competing interests? And what we're doing here is trying to deal with some of the challenges of the existing law, which have recently been made evident by criminal prosecution of folks from Santa Clara County, which I represent. Senate Bill 1399 simply makes clear that a tree or a shrub planted prior, keyword, prior to the installation of a solar collector is exempt from the Solar Shade Control Act and cannot thereby be ordered to be chopped down or pruned, again, under threat of criminal prosecution. Additionally, in order to make sure that everybody knows what's going on, Senate Bill 1399 requires a building owner to notify their neighbors that may be affected prior to installing a solar collector, and also requires a solar collector covered under the Act to be on the building roof. The notion here is that if people have clear notice, it will be easier for everybody to comply and get along. Finally, Senate Bill 1399 provides an additional and clearer avenue for city or county to adopt a related ordinance by requiring a local ordinance dealing with these issues to take precedence without first needing to exempt itself from the Act. Some of you may be aware that Senator McClintock and I share an interest in this subject. He introduced Senate Bill 1493, which was previously set for today's hearing. He has graciously indicated that he would instead prefer to be a joint author on this measure, and I will add him as a joint author of this bill when at such time as we take amendments, so it will end up being a Simitian McClintock bill. The Solar Alliance has raised concerns about requiring the solar collector to be on a roof, as well as some of the notice provisions. We'll continue to work on these issues, but I think we'll take some time to work these out in a satisfactory manner. The one thing we've learned from the case you're about to hear about is that getting the details right on this matters a lot. And with that, I would respectfully ask for an aye vote, but turn to my witness, Richard Treanor, who's here with his wife, Ms. Bissett, and they are folks who had an interesting experience that will shed a little light on this subject.
I think this bill is incredibly fair. If you plant a tree before the solar doesn't count, and I think it's just fair.
Thank you, Senator Simitian. Sir?
Thank you. 1997, my wife and I decided
Your name for the record is?
My name is Richard Treanor, my wife Carolyn, and we're from Sunnyvale, California. And thank you for the opportunity, Madam Chairman and the members of the committee, Senator Simitian, for speaking in front of this. In 1997, my wife and I made the decision to plant redwood trees in our backyard as part of a general landscaping plan. We also put a new lawn in and new sandstone patio and raised beds, and we even had the assent of our neighbor, we thought the trees along our shared fence would give us both some privacy. In 2001, our neighbor decided to install a solar photovoltaic system on his trellis, which was on the north side of our then planted trees. We had 8 redwood trees, and he went to the city of Santa Clara and obtained all the necessary permits, etc., to build his solar system. Only we weren't notified of any of this. We weren't included in any of the permitting process. We weren't allowed to give input. In short, our interests, as far as the city of Santa Clara was concerned.
So you're the immediate neighbor.
I'm the immediate
neighbor.
And
there's no public notice when they make an improvement?
There was no public notice given to us. So we were allowed no input into the process. They essentially permitted his project. We were informed by our neighbor that we would then need to either top or remove all of our 8 trees. So therefore, we fought this. We were later charged with or given a letter of abatement from the city, the district attorney, county of Santa Clara, and we were taken to court to have our trees removed. The judge in the case allowed us to trim 1 or 2 of the trees in order to comply with the state law, and that's where we stand right now.
I think the one other thing I would point out, and Ms. Treanor and Ms. Bissett can correct me, particularly if I slander them in the process, but they both now view themselves as convicted criminals because the court has, after $37,000 in legal fees, the district attorney has been successful, and they ultimately lost the case because the district attorney's reading and the judge's reading of the California Solar Shade Control Act was that they were in violation.